So I did a few consultations this week, where, you know, some of the tougher issues that clients were dealing with is what happens when, there's someone who is on the surface eligible to be sponsored for a green card, let's say either through a family member or through an employer, but there is an underlying complex issue in their case. Um, and this week, what I've been seeing is that some clients who thought that they have had like a straight and direct path to getting a green card through a family member who's able to sponsor them, um, the complicating factor is that the person who wants to be sponsored has had an interaction with immigration court in the past. And increasingly in this day, that is more and more of a reason to be concerned, because you want to know as much as possible um, about what happened in those immigration court proceedings, because it can make a major difference whether the court case was ultimately terminated or if it was administratively closed. There's a very big difference between the two. And a lot of the time, I find that clients, um, first of all, are not really clear on what happens. And secondly, they think that getting a case terminated is the same thing as having a case administratively closed. And that's really not correct. So if a case has been terminated, that means it's officially closed and done with. There is no outstanding deportation process. There was some decision that was made, and for that reason, the judge officially terminated the case. It's not active anymore. But administrative closure is something different. It is not an actual termination. Administratively closed basically just means that for whatever reason, the immigration court kind of placed the case into this kind of limbo indefinite status. And the number one reason why a lot of these court cases ended up being administratively closed is because in previous administrations, there was something called prosecutorial discretion, which basically meant that it's a favorable exercise of the government's discretion, where they know that someone is removable or deportable, but Homeland Security decided to not actively prosecute or pursue the removal of that person. Um, so during the Biden administration, for example, there was a memo that was released by DHS, which basically directed trial attorneys to kind of go through their pending court cases. And then if there were individuals who, let's say, merited a positive exercise of discretion, let's say there were compelling circumstances or humanitarian reasons, then the memo instructed Homeland Security attorneys to agree to or to offer administrative closure to these individuals. So if a case was offered PD, prosecutorial discretion, then usually that just meant that the government said, okay, we know that technically we could continue this deportation proceeding, but we find that there's good reason to not actively try to deport you. Um, so there were lots of cases that were under the status. They were just kind of given PD. Their cases were then just kind of like placed on hold indefinitely. And then when the new administration came in, all of these cases that were kind of put aside, they're now coming back again. And a lot of attorneys are getting notices and, from the immigration court saying this case is now being placed back on the calendar. Um, if I had to estimate, this is like in the tens of thousands, maybe even more. So now all of a sudden, all the lawyers and clients who thought, okay, we've gone through this before and the government has agreed to exercise favorably their discretion to not prosecute, all of a sudden, all these individuals and their family members are kind of like being placed back into deportation proceedings. Um, which is why it's so important that if you or a family member have ever been placed into deportation proceedings, to know exactly what is going on in the case. If you don't have already, try to get a complete copy of your court file. When I do consultations where a client does have some kind of previous history with being in proceedings, the majority of the time, the clients don't have a copy of the entire file. They may have, um, a few scraps of paper here and there. In some cases, they have nothing. They have no copy of the file. Even where they had hired an attorney, they never thought to ask the attorney for a copy of the file, or they have incomplete copies and records. So for your own benefit, obtain a full copy so you can fully understand everything that happens in the court proceeding. Because now, with all of these cases being placed back into the court's docket, and with hearings being scheduled really quickly, you want to know and stay on top, and you don't want to miss a hearing notice, or you don't want to miss the court scheduling you for um, a hearing to appear in court, because if you are scheduled for a hearing and you don't show up, then guess what? The judge can, and in most cases, will order someone to be deported in absentia, which means in the absence, where the person didn't show up to their hearing. Um, so what do you do if you don't have a copy of the whole file? If you have an attorney, or if you had an attorney back then, you can request that attorney to provide you with a copy of the file. It's your right to request a copy of your records from your attorney. Hopefully that will resolve the issue. If, let's say, you didn't have an attorney, or if the attorney that you hired is no longer cannot be located, or won't return your calls, then you can file a FOIA request with the immigration court. FOIA is Freedom of Information Act request. It's basically a request to a government agency to provide you with a copy of any records that they have on you. So I've had to do that for a number of clients where their attorneys did not provide them with a full record of all of the proceedings. Um, but it's really important. Let's say if you now qualify to be sponsored for a green card, but you had an immigration court case at some point, you want to know what was the last thing that was done in those proceedings. Because if it's terminated, then that's great. That usually means if you qualify to, let's say, adjust status based on a petition, then this court case has already been dealt with. But if you, let's say, only had your court case administratively closed, guess what? It is still technically an active deportation proceeding. And then the next question is now a good time to mess with that, right? Um, Usually, if a case is in administrative closure, if I have a client who comes to me and says, I now think I qualify to be sponsored for a green card, but I have this court case that's been admin closed, typically, the next step is you would file a motion to recalendar with the immigration court, asking the judge to recalendar or put the case back onto the court's calendar because there's been a change in circumstances. The client now qualifies to apply for a green card because, let's say, they're now married to a US citizen and they're eligible to adjust. So that court case has to be placed back onto the calendar, and then the immigration judge and the client and or their attorney and Homeland Security, they all kind of have to have a discussion as to, what are we going to do with this case? Assuming that a client is eligible to file for adjustment, who's going to handle the adjustment? Is it going to be immigration court or is it going to be USCIS? So this is the point of filing a motion to recalendar is to like hash out these details. And usually, there will be a discussion between all three parties, the court, Homeland Security, and the client, plus their attorney. Hopefully they do have an attorney, um, to kind of discuss the logistics, sometimes it's a better idea to have an adjustment in immigration court. Um, Sometimes it's okay to request USCIS to adjudicate the adjustment. Every case is different. There's some times when I would prefer that an adjustment stay with an immigration judge. Let's say if there are, let's say, complex legal issues where you feel that a judge will be a better decision maker than a USCIS officer. And sometimes, it might be preferable to have USCIS handle the adjustment. And one example is where, the adjustment is relatively straightforward. There's no real issues about eligibility. And it would take the court a really long time to schedule the adjustment hearing. Courts are inundated right now. So who knows when the next available hearing date a judge can give to, set the case down for merits and, take testimony on the adjustment and issue a decision. If a judge is telling you, look, it's going to be at least 4 years before I have an opening, then I would probably tell my client, you should probably file your adjustment with USCIS and request that USCIS review and issue a decision because it's not going to take them 4 years to issue a decision. So these are the things to think about if you have a situation like this, is to think about the strategy, which is the better government agency to handle the adjustment. It also depends who's the immigration judge, right? And right now, that's another thing that is, there's a lot of changes happening right now with a lot of judges being fired, and then supposedly a lot of lawyers who are JAG officers or um, basically military personnel now being deployed to serve as immigration judges with little to no previous immigration law experience. So it'll be really interesting to see how that plays out. Will these new judges be properly trained and knowledgeable enough about deportation law to issue fair decisions? Um, I have a really big question mark next to that. So it might be more of a risk to face immigration court proceedings right now. Basically, a lot of judges who were fair and who were granting applications, they are the ones who are being targeted and being fired for no reason other than they were doing their job in issuing decisions, granting relief that is requested. And, that's kind of how things are right now, unfortunately. So I'm seeing this happen more and more where clients are scheduling consultations with me because they're coming to find out that they were at some point placed into deportation proceedings. Um, if you're not sure if you ever were placed into deportation proceedings, and that might sound like an odd situation to find yourself in, but you'd be surprised. It could be that if you have been living in the United States for a long time, and let's say you got to the US as a child, I've seen situations where the parents of the children applied for something which ended up getting denied, and then the whole family got placed into deportation proceedings. And if the child is too young to really understand what was going on during that time, they may not really know what happened in court. Language barrier is another reason why sometimes clients don't really understand the gravity of being in court proceedings. They may not really understand, well, what happened in court. So if that's the case, right, you may have to ask your family members, your parents, what exactly happened during this time. Um, I did a consultation a few weeks ago where the clients recently applied for a green card based on marriage. The green card application was approved. She's a conditional green card holder, meaning she has a 2-year green card. And she's only recently found out that as a child, she was in deportation proceedings because her parents applied for asylum that was ultimately denied by the immigration judge. So what do you do in that situation, because there are ramifications to how she filled out her adjustment application. There are questions on the form that ask, have you ever been in deportation proceedings? I'm assuming that she answered the question no, but clearly she wasn't proceeding. Somehow immigration, USCIS did not catch that. So now she's in this predicament where she's not sure what to do now. Um, for those who don't know, someone who is approved for a conditional green card, at the end of those 2 years on the green card, they have to file a petition to remove the conditions in order to get the 10-year green card. When that time comes, the client will have to figure out what to do, right? Because now she knows that she has this order of removal against her. And, um, I basically advise the client that you really should hire an attorney when that time comes, because this is not something you should be DIYing, right? Really, really important to have an attorney kind of give you the best advice and to handle the matter in case complications come up. And that's a situation where, yes, complications will come up. So just kind of be careful. Don't be in the dark. If there's a way to get a complete record of your immigration file, please go and do it. On top of that, I would say it's not enough to just get a copy of your file. If it's a complicated matter, you want an attorney to review the file and kind of explain what impact, what does it mean? What are the risks? What are the next steps that I have to do in order to, remove the conditions on my temporary green card? Um, you know, Equip yourself with the knowledge and get the guidance of like an attorney to properly guide you on the next steps that need to be taken. Um, that's going to happen more and more, I think, as immigration cracks down on adjudication of so many applications, if not all applications. The other things that happened this week are, significant changes in how immigration will process naturalization applications. They just announced today or yesterday that they're going to start using a more difficult naturalization exam. So instead of the old exam where the officers will ask up to 10 questions, and in order to pass the civics exam, you only needed to get 6 correct out of the 10. Now that number has increased. It's now 12 questions out of a maximum of 20. And there's going to be new questions also. Um, so it's not going to be as simple as before. The other thing with naturalization is USCIS is now saying that they're going to go back to their old policy of conducting neighborhood investigations. And what that means is they reserve the right to go and interview your coworkers, your neighbors, and ask them if you're a good person. So I just made a joke on LinkedIn today that, if you have any neighbors that don't like you, then they could really do some trash talking and badmouth you. And I could see immigration coming back and saying, well, we spoke to your neighbor and they don't think you're a good person, so we are not going to approve you for citizenship. So here's your naturalization denial. I mean, it's creating this atmosphere of like, you know, I don't know. It sounds like a very unwelcoming message, I think, because it's arbitrary. What if you have beef with a neighbor, right? What if your neighbor's a jerk? And if they're asked questions by immigration, they can say anything they want, right? It's kind of arbitrary to me. So yeah. Um, I don't think it's gonna be the last change we hear from USCIS about naturalization. I have a feeling that they're going to just tighten the screws, and don't be surprised if they roll out some other changes to how they're going to decide on naturalization, who deserves to be a US citizen and who does not. The other thing that they've been talking a lot lately is denaturalization. So denaturalization means they want to go and look at um, individuals who applied for naturalization, were sworn in as citizens. Now they're going to look back and see if there's any reason to take away that person's citizenship. Um, yeah. So, you know, if you have any concerns, any reasons why you think immigration might target you for denaturalization, I would say now is a good time to consult with an attorney to kind of go over your entire immigration history. Um, Even before this announcement, when someone applied for naturalization, immigration does use that opportunity to really look at someone's immigration history. And I've definitely come across clients who um, have been green card holders for a long time. They finally decided to apply for naturalization. They never had any issues before with being permanent residents, but the moment they applied for naturalization, that's when immigration started digging into their files, and they, lo and behold, found something that all of a sudden now made the client possibly open to deportation. So, just as an example, there are times where, let's say immigration approves a green card application because they weren't aware of some facts, either because they overlooked something in the file or the client didn't disclose it. And the classic example of this is where someone is being sponsored for a green card through a family member. And let's say one of the requirements or conditions to being eligible to receive a green card is that you had to stay unmarried, right? Single. And turns out that the individual is actually married at the time that they sought the immigrant visa or at the time they applied for adjustment. They didn't disclose that to immigration, or they weren't honest. And when they filled out the forms, they claimed that they were single and married when in fact they were actually married. Well, guess what? When you apply for naturalization, there are questions on the form that ask you for timelines, like when did you get married? How many times have you gotten married? What are the names of your spouses or ex-spouses? So that's when immigration pieces everything together and they realize, by the time this person appeared at the embassy for their immigrant visa interview, they claimed that they were not married. Yet they're telling us on the N-400 form that they were married at the time. So guess what that is? They're going to be charged with fraud or misrepresentation. And that could be a basis to take away that person's green card. Not only are you probably going to get your naturalization application denied, but immigration is then going to place you into deportation proceedings. because they're going to say, you failed to disclose this, and had we known, we wouldn't have issued you the immigrant visa because you no longer qualify to receive permanent residence. So that's a classic example. And all the more reason to always be honest when applying for anything with immigration, right? So these are the issues that have come up this week. Things are getting more and more complicated. All the more reason to speak to a lawyer if you're not sure, like, should I apply for this right now? What are the risks that I'm facing? What are the chances it might be successful? Because sometimes it might be better not to file something right now.